My role is to just share some legal updates as it pertains to AI. There's a plethora of them. So I thought in the 30 minutes that I have, I would highlight a couple that stood out to me. And knowing that in the February annual meeting, we'll do deeper dives. And also in light of a lot of obvious overlap with many of our presentations, I tried to pinpoint a couple of things to share with you. So I'm going to go ahead and put this in presentation mode. Okay, so thank you. So I have no disclosures. Our objectives are to review legal issues in AI at the federal and state level, and to highlight some emerging trends with regulations and applications of laws to AI systems, products, and services, and to consider the policy trends as they inform next steps, because as we can see, there's a lot of work to do, And what is our role as experts in these fields and our circles of influence in our organizations and communities. So let's go ahead and take a look. As mentioned, there's a numerous amount of legal implications. This is not an all-inclusive slide, but just to put some on the radar, medical malpractice. We've heard a lot of what is the implication of right to sue, informed consent, privacy, HIPAA, the role of the FDA, insurance and bad faith, in terms of payers using AI algorithms and tools to determine if there's going to be coverage or it's going to be denied, breach of contract, defamation. And the ones I wanted to highlight in the brief amount of time we have is the anti-discrimination protection and consumer protection laws. So let's go ahead and jump in. So at the federal level, just for a backdrop, we know that in 2020, there was a federal law, the National Artificial Initiative Act, that was rendered in 2020. Thereafter, in 2023, there was an executive order for safe, secure, trustworthy development and use of AI. And Dr. Kelly gave a great presentation on the ethics and trustworthiness component. But I draw your attention to this year, where the U.S. Department of Health and Human Services published 2 final rules. And specifically, I wanted to touch on the Section 1557 of the Affordable Care Act that came out in April, May of this year. So Section 1557 is the non-discrimination regulation component under the Affordable Care Act. And this is the first time that we actually see explicit language that extends non-discrimination protections to patient care decision support tools. And also, there was express language that said, bias must be addressed in clinical algorithms and in the use of AI. And then they also, for the first time, included that there's non-discrimination protections in telehealth. So it's a big moment for this to be in a final rule expressly stated that under the Affordable Care Act, which covers many entities in healthcare, including healthcare organizations, providers, payers, pharmacies, and so on, fall under entities that have to abide by the Affordable Care Act. And so now we have language here that's saying that the tools that you're using to make clinical decisions, the algorithms, the AI, they also cannot discriminate. And so I lifted some of the language here for clarity, to be clear, to just drive home the point that the final rule of Section 1557 under the ACA prohibits discrimination on the basis of race, color, national origin, sex, age, or disability in patient care decision support tools, including clinical algorithms. And moreover, it requires efforts on an ongoing basis to mitigate risk of discrimination resulting from the use of such tools in healthcare programs or activities. So it's not a one and done. It's not we validated, tested, and this is how it's supposed to perform. And then you launch it, implement it, and off to the races, and everyone is happy because there's incremental gain, whether it's efficient or it's capturing more or it's drawing to our attention alternatives for management. It's not enough to make sure that those are accurately and consistent and precise in producing the outcomes from a clinical standpoint. We also, in parallel, have to have an ongoing management system, safety monitoring board system, so to speak, to ensure the mitigation of any risk of discrimination resulting thereof. So those unanticipated consequences. And I draw parallels to very similar to what we do with IRBs is, we have unanticipated adverse events and so on. So in parallel, there needs to be a program or some level of oversight to ensure that there's non-discrimination protection for those affected by these AI systems, products, and services. Just one more step further, the Office of Civil Rights, if you go to their website, has already updated to be in alignment and compliance with these non-discrimination protections by the final rule of Section 1557 of the ACA, which advanced protections against discrimination in healthcare. So here down below on this slide, a patient or consumer can go to the Office of Civil Rights, and if they believe they've been discriminated under Section 1557, they can click on this link and file a complaint. And so I just want to pause here because when we think about discrimination under Section 1557, we need to remember that this applies to AI now. It applies to AI clinical decision support tools and also AI clinical algorithms. So you can pause and consider those of us who are in an environment where clinical decision support tools are already deployed, or we think about clinical algorithms, we would want to pause and do an inventory and have a touch point and be sure, have we accounted for any potential discrimination that would be unintended or that needs to be accounted for? What do we need to do to make sure that our current patient clinical decision support tools and clinical algorithms are aligned with this new final rule, with this new language? Because now there is protection and now there's a way for patients, consumers to file a complaint with the OCR. And I'll just sidebar on 2 points here, just food for thought. Is when as we know, covered entities under the ACA includes payers, it includes pharmacies, healthcare organizations, providers, and so on. So when we think about the current federal lawsuits regarding AI tools for denying coverage or approving coverage, and we think about the cases in the federal court system right now for Medicare patients in the Advantage program, you wonder if any of those subsets, I'm just hypothesizing here, of patients would have a basis for complaint under age or a basis of complaint under disability. Most of these patients were elderly. It wouldn't be surprising that they had a disability such as dementia, Alzheimer's, and so on. So it just gives you a pause to consider the implications and the standing now that patients, consumers have. Another one that touches to the area of medicine that I practice is breast cancer. We know that a lot of our high-risk assessment algorithms are borrowed from data from European countries. We have known for decades that those are homogeneous populations that do not reflect the United States patient population from a demographics, race, ethnicity standpoint. And we know when we use these breast cancer risk assessment tools to guide patients on what is the best screening program for them as an individual in a personalized medicine capacity, that it is not accurate for patients from diverse backgrounds. And yet that is what we have. And we don't have more diverse data sets that have improved those algorithms. And you'll hear a lot of conversation about we need more data to better train these AI systems. But if the data is not there, or the data is not being provided for reasons of either these communities don't, there's a lack of trust, or it's just not accounted for, how do we handle that? How do we handle how we advise our patients about their breast cancer risk if we're using algorithms that don't have diverse data? And so the bottom line is, these are the hard questions we need to ask ourselves, because there now is basis and standing if patients are harmed, they can file a complaint. So we need to not just look ahead, we need to not just take inventory of the present, but we also need to take inventory of everything we relied on that was used because we had nothing else. And now it's no longer sufficient. It never has. It's just been that now we have a rule, and we have the Office of Civil Rights now providing a pathway for patients to file complaints. So moving on. At the federal level, there are a couple of other things, some which were mentioned, so I won't spend more time on them. I do want to draw your attention to CMS putting forth guidance that it prohibits Medicare Advantage plans from solely relying on AI outputs to make coverage determinations or to terminate a service. And again, that goes back to some of the lawsuits in the federal courts right now related to the use of insurance programs using AI tools to deny coverage, and those lawsuits are still pending. This one was related to the health information technology products, and that was touched on earlier today, and essentially saying that the AI clinical decision tools must also be accompanied with an intervention risk management program to track those, to manage those, to provide awareness. The other that stood out to me was the work that's being done at the level of the FDA, and we had a talk on that more in depth earlier today. So let's take a step back and look at the states, what's happening from that standpoint. Some of the states that are trending the most for their bold laws being passed are Utah, their artificial intelligence policy, Colorado, consumer protections and interaction with AI systems, and California with their generative AI training data transparency acts, as well as their Consumer Privacy Act. And I know that we had a fantastic talk earlier this morning that dove into the specifics on those. But when we take a step back, you know, at any point in time, the numbers are fluctuating, but I can report that at least 31 states have passed some form of AI legislation. 11 states have passed laws on disclosure of AI use or disclosure of data collection for the purposes of AI model training. 22 states have passed laws creating a task force or an advisory council on AI to study how the state agencies can use or regulate AI. And 12 states have passed laws related to civil liberties in AI, for example, restricting law enforcement using facial recognition technology or AI-assisted algorithms. If we take another step back, let's look at this map to see how much of this AI legislation impacts healthcare or is directly related to healthcare. And the dark blue states are states that have passed bills related directly to healthcare AI or are implicated by AI used in healthcare. And the blue states have bills that are pending. And so you can see about roughly half the country has already taken steps, or they're in the process of moving forward. And so more to come here. So it's very, very in flux, a lot of action, a lot of play action on the lay of the land here. And as you can see, it's going to produce a patchwork of varying AI laws and regulations as the states move forward and as federal oversight in parallel is evolving. So we want to know who is being regulated with the laws that are being passed in the states. And you can see on the radar, providers and payers are accounted for. They're still on the low end of the spectrum, but they are on the radar. So it wouldn't be surprised if we see an uptick in 2025. We see some cases brought forward trying to test liability. In addition, you can see that the bell here, if this were a curve, that developers and deployers, so it's not just the developers, but it's also the procurers. So this brings in our organizations, our health institutions, our departments, and so on, and even insurance. That it's not enough that how you developed it, but who purchased it, who's using it, and who's putting it in play, executing it. So we're seeing that they are being regulated to the same degree as the developers. And then also state agencies, how the state, we tend to think of healthcare as more private, public sector, but the government is a big player in healthcare, the state agencies that regulate, oversee. And so we're seeing a lot of traction on how the agencies are being regulated or the guidance and rules that they're issuing for their respective territories. In regards to what is actually being regulated, you can see that the majority is going to fall in the area of transparency, not just for the end user, but also to the state, the reporting part of it. You're going to see that in the center here, we have the anti-discrimination protections. We're seeing a lot of state laws being passed to expand those protections or to codify those. If we move lower down, we see that what's being regulated is the determinations of insurance eligibility, the medical necessity, and or authorization. So states are, as everyone waits to see how the federal lawsuits are finalized and the outcomes, states are already making movement towards trying to deal for their respective states, how this will be authorized and regulated. And then lastly, I want to point out here, because this is one that's I think very important, is how are the states aligning with national standards and also in terms of AI, but also with the administration's AI blueprint. I think that's critical because as we're trying to all put our arms around this, the administration and the federal standards also have to at some point link out with international global AI standards and human rights. So it's all connected. And so you can see that some laws are being worked on or have been passed to make sure that that's front and center. So let's take a look at some of the evolving landscape in what caught my eye, which I thought was interesting, exciting, also gives me pause because as we know, there's some gray areas and a lot more to be seen. But in terms of the first part of the talk, we've talked about what's new, what's being developed, and its application for AI. For this part of the talk, what we're seeing is current existing law, for example, consumer protection laws, how it's being leveraged and interfacing with AI. And so we'll look at the U.S. Federal Trade Commission and state attorney generals. So the Federal Trade Commission has Operation AI Comply. And that was announced and launched in 2024. And as we know, Congress has given the FTC the power for Consumer Protection Authority, AI or otherwise. The FTC has announced that it will take enforcement action against claims it finds to be unfair and deceptive, and specifically put out a notice in September, so just a month ago, that it's going to crack down on deceptive AI claims and schemes, that it will take action against AI hype or deceptive and unfair AI. And it actually highlighted this notice that it put out, a warning to companies against violation of the FTC Act, specifically with false or unsubstantiated claims regarding AI accuracy or safety. It also said, hey, you're violating the FTC Act if you retroactively change the terms to your service or privacy policy for the purpose of sharing consumer data with third parties for AI training or AI training. And so it's kind of throwing a flag out there and saying, be warned that we're looking at this in terms of how does it violate the FTC Act. And so along with that notice, they announced 5 enforcement actions that serve as case examples. And the one I wanted to draw to your attention is the do not pay matter. So this is the FTC filing a complaint against Do Not Pay, alleging that it had violated the provisions of the Federal Trade Commission Act. And looking at the actions of Do Not Pay, what they marketed and advertised to consumers was they were the world's first AI lawyer, that they were the world's first robot lawyer, that they are the general counsel for consumer, that they generate perfectly valid legal documents in no time, and that their goal was to replace the $200 billion legal industry with AI. Furthermore, they represented that their products, their service, was an AI lawyer in legal services such as ironclad demand letters and contracts, complaints for small claims court, could appeal your parking ticket, and they promised much more. So here's an Exhibit A that the FTC submitted with their complaint, and this is an image of their of Do Not Pay's online website at that time, and you can see here it says the world's first robot lawyer. And further down, it says, fight corporations, beat bureaucracy, and sue anyone at the press of a button. Here's Exhibit B that the FTC submitted, where Do Not Pay advertised, marketed that they were automating the legal system. Here's Exhibit F, where the FTC submitted that Do Not Pay included on their marketing, on their website, quotes from the LA Times. This one said, what this robot lawyer can do is astonishingly similar, if not more, to what human lawyers do. So as a result, the commission filed an administrative complaint and said, Do Not Pay, you have participated in deceptive marketing of generative AI. Your claims are false, misleading, or unsubstantiated. The commission's complaint also alleged that Do Not Pay fell far short from all the promises that they had advertised and marketed to consumers. They further alleged that its own employees had not even tested the quality and accuracy of AI services, and that it advertised some features that it didn't even provide. So as a result, they entered into an agreement, a consent order, and here are listed as provisions 1 through 11, where they're prohibited from misleading and unsubstantiated representations. The monetary relief was $193,000. They were to provide the FTC Commission customer contact to administer consumer redress. They're supposed to provide eligible customers with notice of consent, the order and settlement. And then they entered into a reporting and compliance agreement that spans anywhere from 5 to 20 years, depending on if it entailed the reports, notices, record keeping, and monitoring. So an example at the federal level of current law just being applied to a case of AI from the lens of consumer protection laws through the FTC. I thought there were some impressive statements by the Commissioner Ferguson in his opinion, and I pulled those out to share. And one was holding generative AI companies to the same standards for honest business conduct that apply to every industry with the regulation of AI. He said that the commission will enforce Section 5 of the FTC against businesses that deceive customers about capabilities of their generative AI services. And the other one that I pulled from the concurring statement opinion was businesses that exploit media hype and consumer unfamiliarity with this new technology should expect a knock on the door from the commission and other law enforcement agencies. So thought very telling. And again, there's 5 other enforcement actions where you can see that they're consistent in saying that when it comes to disclosure, when it comes to marketing, advertising, you cannot violate consumer protection laws. And so that's just a different way of thinking about accountability for our AI system services and products, and what results can be expected as we go live very quickly and up ramp across the healthcare industry. So in parallel, we're seeing a similar play at the state level. This is an example, a case in Texas, where the Attorney General investigated a generative AI healthcare tech firm, Pieces Technology. And the Attorney General's office alleged that real-time patient data was being submitted to generative AI, which is Pieces Technologies, to summarize clinical notes and charting and drafting them for entry into the electronic medical record. Pieces Technology claimed that their generative AI product had an error rate of less than 1 per 100,000. And the Attorney General's office alleged that at least 4 hospitals in Texas likely relied on these claims in choosing to use the generative AI in patient healthcare settings. So in their investigation, the Attorney General's office in Texas alleged that this was false and misleading, deceptive, and these statements were not accurate in regards to the safety of that AI service, and therefore violated the Texas Deceptive Trade Practices and Consumer Protection Act. So these were all allegations. As a result, in August of this year, Pieces Technology entered into a voluntary compliance with the state of Texas. And the significance of that is that it imposed compliance provisions for 5 years. And what it comes down to is you need to have clear and conspicuous disclosures in your marketing and advertising all the way through the end user. And you need to be able to back up your accuracy, safety, and appropriate use of your AI tool. And you cannot misrepresent. So that is how we're seeing consumer protection law play out at the state level. So another example where the federal government and the states are moving in the same direction, but using different current existing laws and applying them to cases where AI is being deployed in their states or at the federal level. So this is a quote that from the Texas Attorney General, Ken Paxton, and his statement was, AI companies offering products used in high-risk settings owe it to the public and to their clients to be transparent about their risks, limitations, and appropriate use. So we're hearing the same talking point. I think a lot of last year and even the years prior and even this year, it's a lot about accuracy. It's a lot about safety. But now this is the year where it's really transparency. And it's not enough to be transparent to your, what we're seeing, it's not enough to be transparent to your procurer, but also to your end user. So with that in mind, what are the next steps and opportunities? Where do we start? It is a patchwork out there, and everyone, it's like trial and error in the state laboratories. At the same time, we have evolving federal oversight that we have to align with. So it's an exciting time. It doesn't seem like any of what we're seeing so far is to suppress innovation. It's just, what are those guardrails? What are the safeguards? For ensuring that as we move forward, that all our pre-existing law and policy are updated so they also apply to this innovation. And for the cases that are new because of this new emerging technology, what needs to be crafted to bridge the gaps so that we retain the same spirit of the law and policy, so that we all move in the same direction together. We cannot underplay or downplay that the scrutiny is not just on developers, but the responsibility is also on the procurers and adopters of AI, and cannot overstate that that includes all of us, providers, payers, and organizations, which is one of the reasons why we have the symposium today, because the data is moving so fast. We need societies like our college and other partners to keep us abreast of best practices, latest updates, so that we can be informed and lead in our respective communities and spheres of influence. But what I want to, if there's anything that you take away from what I've shared in these 30 minutes, is really this is the year of where we actually get to, I can't wait any longer. How does this impact patients, consumers, and the public interest? That has to be just as important as the excitement that we have about the gains that it provides. There should be no conversation where we leave out the impacts on the public interest, patient, and consumers. So lastly, just one final point. What are the next steps? They're the same fundamentals, same place. We want to get the next down, and the best way to do that is we need to have your organization, your practice, your firm, where your sphere of influence, what is your AI governance and compliance program? You should be able to point to it. You should be able to know who the leadership is, the committee, the task force, advisory council, and what is your link out to your state? What is your link out to the government? What is your link out to organizations like our College of Legal Medicine? Along with that, we know accuracy, safety, and proper use throughout the continuum: development, testing, implementation, and execution. And the implementation and execution part of it really speaks to what we see the FTC and state attorney generals doing, is you have to have appropriate disclosures, you have to disclose your limitations, and some of that dovetails into consent as well. And so when this can all sound overwhelming, where do you start? We don't want to reinvent the wheels. I just want to draw your attention to a resource at the level of the federal government under the U.S. Department of Commerce, which was called upon to issue an AI governance plan and compliance program. And they were called and tasked with this action item with the National AI Act of 2020. So they rolled out under their National Institute of Standards and Technology, NIST, a risk management framework last year. This year, the reason why I added this on this slide is this year they rolled out what that looks like for generative AI. They did a profile on it and how it fits into the framework. So I thought that was very exciting, and I'll show you here in a minute. And then lastly, they give a playbook, a plug and play that you can right size to your organization, whether it's private or public or even individual. And so this is just an image from their website where it talks to you about the resources. Here is another example, and I included the QR code if you wanted to use that to get this information, but it provides the roadmap, cross walks and perspectives, which align with, this is the part that aligns with national and international standards and so on. So there's a lot of ways to get things done. Sometimes it's great to have a plug and play. And this is what this federal resource is meant to provide. It's also good to have a benchmark. So if your organization has already agreed on a certain format or structure or process, it's always great to have a benchmark and to compare if there's anything that you might want to lift or add from this framework and include in your very own. And here's just another example from the framework of more of an environmental scan approach. And I'll draw your attention to the end of the spectrum here, where it really focuses on how it interfaces with the consumer, the public interest, and patients. So within there falls consent, transparency, consumer protection laws, and the ability to be able to ensure the ethics and that the public interest is also of high priority and on the radar throughout this process. So in conclusion, the take-home points are that it's all about AI governance and compliance programs and keeping up with the change and shifting landscape of state laws, federal laws, administrative law, and then we haven't even touched on the court cases and the developments of those cases. And so this is a big infrastructure. It needs to be strong, and you need dedicated leadership and experts that are keeping everyone abreast. Secondly, we still need to ensure that we have accurate, safe, and proper use and deployment of AI systems. But more importantly, this is the year where we really focus on how are we transparent? How are we communicating to our communities, to the public, to consumers, to patients? Not only are we disclosing that we're using, how are we disclosing that we're using their data? How are we disclosing that we're using AI in part of their care? How do we disclose the limitations to them if we do use that AI? And at the end of the day, do we have their consent? Can they opt out? These are still things that we're grappling with. And we all have our experiences, and we can kind of predict just based on the lay of the land of where we think things will go. But this is still very evolving at the moment. So in summary, we briefly discussed some of the legal updates in AI at the federal and state level. We've highlighted some emerging trends with AI technology and their intersection with regulations, and we considered policy in regards to next steps. Thank you so much for your time.